Hi there, everyone. Thanks for joining us as we plan to talk today about the Biden administration's new order announcing parole in place in order to help some undocumented spouses of U.S. citizen and some of their children, and some additional changes, updates to our current immigration system. So we'll be talking about that. My name is Emily Newman. I'm the managing partner of Reddy Neumann Brown here in Houston, Texas. We're one of the largest immigration law firms in Houston. And with me today is one of my business partners, Stephen Brown, who is handling all of our litigation, non-immigrant visas, lots of different types of cases here. And so we want to go through what's in this executive order, what isn't, what it does do for people, who it's likely to help, and who it unfortunately leaves out. So Stephen, can you give us kind of a little introduction into what this order is and who's eligible for it?
Yes. Yeah. Thank you, Emily. So there's really, the way I view it, is two actions that are being taken here. And this is largely to help out the those that are undocumented. We have proposed, we have announcement one, which is for spouses, and I believe it's spouses and children of U.S. citizens, if I'm not mistaken. And then number two are the folks that are in DACA and have U.S. degrees. And so the Biden administration, making good on its 2020 campaign promises, is trying to work on a path for these individuals. I know you and I talk about it all the time. Congress continues to be complacent on anything immigration. And because Congress continues to be complacent, what we're left with is executive actions. And from everything I've read, there's a lot of good authority for this parole in place. Remember, this is very similar to the authority that was used for the military parole in place that was extended under the Trump administration. This is just a new flavor of that. Instead of military members, we're talking about the immediate relatives. Now, when we talk about this, one of the initial concerns, one of the initial things that I think was a misrepresentation is that Biden is creating a new path to a green card, and that has to go through Congress. And that's absolutely not what's happening here. When you are a spouse of a U.S. citizen, you are already eligible for a green card. Most of these individuals would have their green card, but for the unlawful present issue that is a hurdle for them. And so this removes that hurdle. And then just, to kind of put a bow on it, with these immediate relatives, they aren't subject to caps or the visa bulletin. So this doesn't have any of the negative impacts on the visa bulletin or progression or lack thereof on that. Now, we'll talk more about the DACA side of that and the impact that might have on employment base. But overall, I think this is it's a good step, and we'll talk about who it leaves out, because I think there's a lot of folks that unfortunately leaves out. But this is making good on a campaign promise.
Yeah. So one of the questions I've been asked is, this is called parole in place. Does it do anything to help people applying for advanced parole? We know that advanced parole processing times are ridiculous, over a year, to get a simple travel document that probably takes 30 seconds to approve. And now all of a sudden we're going to be adding these new paroles into the mix. So is this the same type of parole? And if undocumented immigrants can get this parole, can legal immigrants get this kind of parole? And unfortunately, this is a different kind of parole. It's not called advanced parole, because with advanced parole, you are asking the government permission in advance to allow you to exit and come back in without abandoning your pending 485 green card application. Parole in place is another type of permission you're asking from the government, but the in place part of it means that they're letting you do it while you're in place, while you're in the U.S. You don't have to exit to ask in advance to be paroled back into the country. You can do it while you're in place. And what it really does for people who are undocumented spouses of U.S. citizens is it provides them now with a method to file an adjustment of status, because what's preventing undocumented spouses of U.S. citizens from receiving that green card right now is the entry without inspection. So a lot of these people, the general rule for spouse of U.S. citizen, if you came into this country legally and you've overstayed by 20 years and you've worked without authorization for 20 years and then you marry a U.S. citizen, you are qualified to file for adjustment of status, assuming you don't have any other grounds of inadmissibilities. These people don't have that option because they entered without inspection. So the only way for them to receive a green card right now is through consular processing. They cannot do adjustment of status. Consular processing means they're going to have to leave the U.S. in order to receive their green card through the consulate. However, when they leave the U.S., they're going to trigger the 10-year bar to them coming lawfully back into the country once they get their green card. They won't be able to get that green card for 10 years. So we're basically forcing families who've been together, already married to a U.S. citizen, to separate for 10 years, or we're forcing the U.S. citizen spouse to move to their other country for 10 years in order for this person to finally qualify for a green card and come back in. The other way to qualify is if you can show that your U.S. citizen spouse would undergo extreme hardship because of this family separation. That is the I-601 or 601A waiver process, which most of these people qualify for. The problem is the 601 waivers are taking 3 years. So we are delaying things further. The government can't keep up with that process. So instead of making them go through all of that rigmarole when they're already here, just give them parole in place. Once they do that, they're no longer entry without inspection. Now they've been paroled. And for family-based immigration, marriage to a U.S. citizen, you can file adjustment of status based on an entry by parole. So with this parole in place, it requires the marriage to a U.S. citizen. It requires that they be in the U.S. for at least 10 years as of June 17th, 2024. So it's not going to help anyone who came in 9 years ago. 9 years and 364 days ago. You've got to have already been in the U.S. living here for 10 years as of June 17th. And then beyond that, they're going to check for criminal background, national security risks, all the same kind of things that they did for DACA. So assuming they have a clean record and their only violation is entry without inspection, they would be able to get this parole, which is valid for 3 years, and that gives them employment authorization or the ability to apply for an EAD. And then during that 3-year time, they can then have their spouse file the I-130 if they haven't already, and the I-485 to adjustment of status. They receive their green card while they are in the U.S. So that's kind of how the program works. As Stephen said, it's not a new process, this parole in place. It's not a new idea. They've been using it for military spouses for some time, 10 years, I believe. Even the Trump administration was still issuing those. Even though there's authority for this, what are your thoughts on litigation, and will this actually come into effect?
So, I think the commentary that I've read and looked at, there's a lot of good authority for this. This is a lot of wide discretion in this. And we'll talk a little bit later, because I know one of the common questions is those in the backlog community. I think there's similar discretion there too. That just because it's allowed doesn't mean there's not going to be litigation. It will ultimately be to a judge. Now, whether I don't really think those lawsuits are going to be successful, but that's not going to stop these anti-immigration attorneys general, right, across the nation who sue on everything immigration related. It's not going to, stop anti-immigration groups from potentially suing to stop this. I mean, we've already seen rhetoric from some of these groups. This is a mass amnesty program, and this is just giving, the language I've seen, we're giving illegals green cards. No, that's not what's happening here. This is all about family separation, and making this path for people who are otherwise eligible for a green card today, right? There's nothing created, right? Last week, they were eligible for this green card. It's creating an easier path for them to get it. And that's all this is doing. So I don't think we're going to see successful litigation in the long run. That doesn't mean we don't see something like a judge in Amarillo, granting an injunction and it getting fought all the way through. That doesn't, so a couple of things on this. One, we've seen all the fact sheets and what DHS has put out, but we have yet to see anything in the Federal Register that is formalizing this. What are going to be the regulatory processes? How do we do this? Do we file an I-131 or do they have a new form? What do we file? What are the fees? We don't know. That is not published yet. I know some folks are speculating 30 to 60 days, maybe, on this. We'll see something in the Federal Register, and then there will probably be some sort of comment period or, enactment period, whatever it might be, on that. So we don't have anything today. And I guess my point is that if you are talking to a lawyer who says they can take your money today for this case, I don't think you should do that, because we don't know. We don't know anything about how this is going to go just yet. But so keep an eye out for that. And then so once that regulation comes through, then we might see the litigation efforts.
All right. So I mentioned earlier that what this is ultimately doing is eliminating the 601 waiver process for this group of people. So let me talk about how many people is this in the first place. So we do not have a actual real count of the number of undocumented people in the United States. I think the best estimate is about 10.5 million. That comes from the Pew Research Center. They've been tracking it for quite some time. So 10.5 million, but when the government made this announcement, they said that about 500,000 is how many they expect will actually qualify for it. So we have 10.5 million, only 500,000. That's less than 5% of our undocumented population that might actually qualify this, because not every undocumented person is married to a U.S. citizen. Not every undocumented person has been here for more than 10 years. So if we are eliminating the 601 waiver need for 500,000 people, and we are now adding some sort of application for parole in place that they will file instead, plus once they get that parole in place, now 500,000 more people are going to be applying for adjustment of status. What do you think that's going to be doing to processing times for everybody else who's waiting for their 485 to be approved, who's waiting for their advanced parole to be approved?
It is concerning. And I'm hoping, but I don't trust the current powers that be, that they would properly staff this. But one thing we look at, when we talk about delay litigation, is what are the competing priorities, right, of the agency. And if DHS goes out and says, this is our top priority, this is number one, right, that could significantly impact anything else down the road that isn't this. Now, again, my hope is that they try to staff this right. I'm not going to hold my breath on that happening, because we just haven't seen that proper management yet. But I do think that they are going to prioritize these and maybe push on these. And we are talking about so much. And then what are those processing times? How does a potential change in administration maybe in January impact this? And so there's a lot of what ifs out there still. But I do think we could see some downsides on the processing. Granted, my view on advanced parole is those should go from being received to printed anyway. So maybe they do something right, but I'm not holding my breath.
Yeah. And DHS says 500,000 people, maybe an additional 50,000 kids might qualify. These are kids of the undocumented spouse, so they're stepchild of the U.S. citizen, and they also entered without inspection potentially. So 550,000. But how many green cards does USCIS issue every year? Over 1 million. And most of those are in the immediate relative category. So we're not even talking about a year's worth of applications. And they might not all come at the same time either. I think the whatever parole in place application might come all at once. But then the actual adjustment of status processes might be carried out over time. And it's kind of somewhat a drop in the bucket compared to the total number of 485s and green cards that they issue every year. So hopefully that won't be an issue. But the fact that they say again and again in their announcement that this parole in place, it has set requirements, the 10 years, the married to a U.S. citizen, but we're going to look at every person on a case-by-case basis to make a determination in our discretion whether they qualify. Well, guess where else they use their discretion and blame that on long processing times? Advanced parole. That's why they claim that they can't just print an advanced parole for employment-based as soon as you file it because it's discretionary.
Right.
Well, how many times are they using their discretion to deny these? Like less than 1% of the time. Let's get the other 99% done. But they're already taking 3 years to process the 601 waivers, which are also on a case-by-case basis and discretionary. We're just going to change that burden from 601s to whatever form you have to file for this parole in place. That is concerning to me that they're just going to use this case-by-case basis to review everything so much that they never get the approvals or it takes forever. And we're going to have to be suing on those in addition to suing on advanced parole delays and 485 delays. So one other thing that's in this announcement that I think has the potential to impact our audience, which is more employment-based, is the fact that they are planning on allowing people who are here undocumented, whether they have DACA or not, but who have gone to school here, got a U.S. Higher degree, so a bachelor's degree or higher from an accredited university, they're going to allow them to more easily get a visa at a consulate and come back on a work visa. So we have a new group of people who are now going to be potentially qualifying for H-1Bs. It could impact the H-1B lottery coming up next year as employers now are sponsoring undocumented people for H-1Bs, which they were never able to do before. Or you could sponsor them, but then it'd be worthless because they could never get the visa. Now, once the company sponsors and they receive the petition approval, these people will, we think, this is all guessing at this point because there's very little details. My only thought as to how I think this is going to go is because they mentioned the Department of State, which handles visas. So I think they're going to exit, and when they apply for the visa stamp, like all of us have to do, normally these people would be denied a visa on the ground of inadmissibility of unlawful presence or potential entry without inspection, but most likely unlawful presence. That requires a waiver. I think their plan is to kind of make that waiver process streamlined for people in this unique situation so that they can easily get the visa, come back into the U.S. in that non-immigrant status. So now they are using some of the H-1Bs. They might be using TNs. They might be using E-visas. They might be using O-1 visas. So any kind of work visa that we typically associate with employment-based immigration, this new population will be eligible for. Now, once they get that waiver and come in on a visa, now they have a legal entry and can potentially be sponsored for the green card by their employer. They can be sponsored in EB2. They can be sponsored in EB3, EB1, just like everyone that is in our audience. These are more likely to be rest of world countries, which means more people are going to be using rest of world green cards. And because they were able to come back in on a non-immigrant visa, that 10-year bar that I talked about earlier still applies to them for the green card, but they can be serving that 10 years while they're lawfully in the U.S. under a new policy that was announced a couple of months ago, years ago. I can't remember. It's not too long ago. So this has the potential to impact visa bulletin, to impact retrogression, to impact the ability of everyone else who's already waiting to get a green card, because rest of world numbers may be used up even more. That's less spill across that can go to EB2, EB3, India, China. So I don't know if you have anything to add to that, Stephen.
Yeah, I mean, let's the immigrant visa, the green card part aside. This is, I think an H-1B lottery aside. I mean, for the DACA kids, this is a great policy for them, right? When we talk about the 212D3 waiver, we're talking about years of processing and a lot of discretion that makes it nearly impossible for these employers, like you said. Now they can, go get the H, a TN, an O1, whatever it might be. Maybe start a business, through an e-visa potentially. I think you'd have to finagle that one a little bit. But this is good, from that side of it. And I do applaud them trying something. It's just we need to keep an eye out on what are the follow-on effects of this. Like Emily said, we're gonna see, we could see folks that were never in the H-1B lottery now enter. They never even considered it because it just was impractical. And that's already bad as it is. So we'll keep an eye on it. Again, we don't know. We just do not have all the details on what they are going to do. Now, I did see one question, and I know we'll get to more here shortly, but a question about, hey, I've been engaged, but otherwise I meet all the requirements. Can I qualify? And the answer, unfortunately, is no. Now, I think it is very clear you have to have a legally valid marriage to a U.S. citizen as of June 17th, 2024. Now, I have seen some attorneys who have argued that if you are married to an LPR who gets their citizenship, you might be able to qualify as long as that marriage was before then. The plain reading on DHS's website, I think you have to have been married to a U.S. citizen as of 2 days ago. So we'll see. But if you've been engaged and not married before June 17th, unfortunately, this doesn't apply. This doesn't qualify you.
All right. Now I want to get to the elephant in the room, at least for probably our audience, is what's not included in this executive order. This does nothing for legal immigrants who are waiting just as long. How many of our clients have been here for 10 years? So many, and still, can't even file a 485. And then the ones that have been able to file it are stuck waiting another 8 years because DOS doesn't know how to move the visa bulletin. So we have no relief for people with approved I-140s, even though that's been a recommendation made to the president. We have what's more, we've talked about DACA, but we have documented dreamers. We have kids that are, kids of long-term visa holders, came here lawfully, still here lawfully, aging out. Nothing for them, even though all you see on Twitter these days is people promoting relief for documented dreamers. Rightfully so, they should be. But how is it they left that out of this?
Well, that's not an unfamiliar concept either with the government. Remember, it was in that one immigration bill that came out in February, I think, where they tried to do something for the documented dreamers. And unfortunately, that didn't come to fruition. But you're right, it's left out here.
And then, as you mentioned, there's no announcement in the Federal Register yet. So that means we don't know what form people will have to file if they do qualify. We don't know what the fee is going to be, and we don't know what documents are going to be required. But we can guess at some of those. So if you are someone who miraculously can qualify for this and meet the limited requirements of it, what you can be looking for and gathering now, number one, is proof of your continuous residence in the U.S. for the last 10 years. So that would be utility bills, lease agreements, tax returns. We know undocumented immigrants file their taxes. So you'll have that as proof of your residence in the U.S. Of course, you have to be legally married. So you'll want to have that marriage certificate showing that you were married as of June 17th. You're going to need proof of your spouse's U.S. citizenship. So either their birth certificate in the U.S., certified copy of it, their passport, or their naturalization certificate. Your proof of identity. So you're going to need a driver's license, a passport, consular ID, something like that. And then we expect there's going to be some kind of background check. I don't know if it's going to require a police clearance certificate, like is common for consular processing of green cards. I suspect not. I think it's going to be more like DACA, where in filling out the form, they ask you, have you been arrested? Have you been convicted? Have you ever served prison, jail, that sort of thing? They ask you those questions. And then, of course, they're going to run their own background check, but I don't think they're going to require you to be fingerprinted and all of that stuff up front. That's my guess. We'll just have to wait and see on that. And then I just want to touch on, as you mentioned, Congress is absent, but we do need Congress to be the one to fix these things because these executive actions they have their limitations. Number one, we can expect litigation. So that's going to slow this down. Number two, it's at the whim of whoever the executive happens to be. So if we get another president in January, they could turn around and dismantle all of this, just like has been tried to do before. So sadly, it's a somewhat step in the right direction to at least help a small portion of people. Does not go far enough. And we definitely need more, but we can go ahead and go to some of the questions we have here.
I wanted to address two of them. I got SK, and I'll combine his with Amit's here, but why can't we have an executive order on recommendation for Ajay Jain and the team on the EADAP for approved I-140 holders over 5 years? And Amit on YouTube, similar question, anything H-1B with I-140 with 10 years in the USA. Again, nothing here, but I fully agree. I think the president, the executive branch, has very good authority to enact those recommendations. We have seen through litigation on STEM OPT, H4 EAD, courts routinely hold that the executive branch has very broad authority on EAD and work authorization. And same thing for advanced parole. So if the administration were to propose, okay, if you've got an I-140 and it's been 5 years, or hey, you got an I-140 and it's been X number of years, whatever, and they want to do it at EAD and AP, I think they are well within their authority to do so. And I think it would be a step in the right direction. I think giving you more of that mobility and freedom and not having to keep filing a renewal every 3 years. But again, also, they could come up with something potentially for the documented dreamers too. And I maybe do a parole in place or something for them. Some of these kids, and I've met them, they've been here since they were 5 or 6 years old. Their parents thought, okay, the visa bulletin in 2012 was really a 5-year difference, and thought, eventually I'm going to get a green card. I don't have to worry about this. These kids have grown up going to school, and been here for all of their life for the most part. I really do hope that they take that seriously and start trying to come up with solutions. But unfortunately, it's not here. Hopefully that changes in the future.
All right. And yes, if you are on our YouTube channel or you go to our YouTube channel, in the show notes for this, we have so many different templates for you to use to contact the different agencies, different councils and authorities that can help us get some of the reforms that will help the legal immigrants, like the EAD and AP for people that have had an I-140 for so long, like not counting the dependents in the green card quota. You don't count dependents for H-4 to the number of H-1Bs that are issued. You don't count dependents for anything. And the statute doesn't really say you have to count dependents. It's just how they happen to interpret it. So let's get them to reinterpret it. That would triple the number of green cards available. Definitely make your voice heard on those. There is an upcoming White House initiative on Asian American Pacific Islanders. Sorry, it's got a really long name, WHIAANHPI or something like that. They are seeking feedback from the Asian community about the immigration system. And we're working on creating a comment for that you can take and use and submit. Hopefully we'll get that posted soon, but we need you guys to speak up. A lot of the time we are advocating for reform, we're complaining about all of the problems, but no one's actually doing anything about it. There was a rally in Austin earlier this year specifically for people stuck in the backlog, trying to raise awareness of that and the 7% cap and how it's hurting families, how it's hurting the economy. And there were only like 6 people that showed up, and I was one of them. I shouldn't be the one showing up. You guys need to be showing up. So you guys need to start acting more, get the word out more. But going back to the questions, Viramani says, will this have any impact on processing times for H1s, H4 EAD extensions? I think regular processing times, potentially, yeah. As Stephen mentioned, they have supposedly limited resources. They are not very efficient. And so if they're going to prioritize these parole in place applications over H-1B applications, you can see H-1B, H-4 EAD processing times getting longer because they're focusing their efforts on these cases. But if you're filing in premium, that should not change because that is regulatory. It has to be 15 business days now, not calendar days anymore. And you can get all 3 approved. Of course, you shouldn't have to pay an extra $2,805, but that's really the reality of it, is we need to.
Sanjay notes that he's written as a Texas resident to his representatives and senators about the EAD and AP. And all their replies are, we need to fix the border first, and then let's talk. Yeah, that's a shocking for especially the Texas representatives. But again, I think it's fully within the authority of the White House, and I think the more people tell their story. I saw one this week from Improve the Dream. There was a kid who had to go abroad. He's working in the semiconductor industry. Well, not too long ago, Congress passed the CHIPS Act, and Biden signs an EO about the CHIPS Act, about how we want to become leaders in the semiconductor industry. Well, if we want to be leaders in the semiconductor industry, why are we having folks leave the U.S. that are in that field just based off of these arbitrary rules? I mean, I know Congress set them, but there's workarounds. So I think telling the story is important, and telling what you do is important.
Yeah, and kind of a follow-up on that, someone says that they're fearful that public activism will negatively impact current, future approvals, extensions, that sort of thing. Understandable. But you have to think back. this is kind of a civil rights issue. Look at the civil rights giants that came before. They, I'm sure, were fearful too, but they did it anyways. And I think there should be less fear in this situation because the type of activism we're talking about is not anything that's going to get you into trouble. You're not going to get in trouble because you sent in a letter. You're not going to get in trouble because you showed up at a protest, as long as it had its permits and was, done legally and that sort of thing. So I think that's maybe not a valid excuse.
Well, and remember, Emily, the DACA kids pushed for action, and
Yeah,
we're
they're
out there.
completely undocumented, illegal here. Like ICE could come for them any minute. And they're on social media saying, I am undocumented, but this is my life. This is my story. This is why this is important to me. So yeah, if DACA kids can do it, you can do it.
Yeah, and I know the past administration was maybe trying to do things to end the program, but there was nothing about individuals, right? There wasn't, well, I'm going to get rid of so-and-so's extension, right? Because they are protesting, that I ever heard of. So I get the fear, Sanjay. I really do understand it, but I don't think I think it's time to move past the fear.
And we are in America.
Yes.
Freedom of speech is a very important tenet for everyone who's physically in this country, regardless of what your immigration status is. So take advantage of that. Another question, this is from SG. Any update on stateside visa stamping since legal immigrants are not being favored in this provision? Somewhat of an update came at AILA's conference last week. They made it sound like everybody loves it and they want to expand it, continue it, but might not be till the end of the year that we see any action taking on it. So they've got to get all their ducks in a row. And I'm sure with our government efficiency, they'll take forever to do it. But they are planning to continue that. Okay. I think the rest of the questions aren't really related to the topic. But yeah, I think that's all we had and wanted to share. Thanks everyone for joining us. Hopefully we've lit a fire under you to take some more action, take things into your own hands and advocate for some reforms that will help our community in the current environment. Thanks, Stephen, for joining today.
Absolutely. Thank you all.